Dear guests, dear clients, dear fans of Tech and Law TV, welcome to our show today. We are talking about the AI Act, AI law and GDPR. Is this a difficult marriage, and how these two components, legal components, work together? And I'm very happy and maybe even proud to have Thomas Fuchs here today in our show. Thomas is the Hamburg Commissioner for Data Protection and Freedom of Information in Hamburg. So he's the head of the Data Protection Authority in Hamburg, and he is extremely knowledgeable about AI. That is a new topic for the data protection officers. So welcome today, Mr. Fuchs. Thanks. You very much.
Thanks for having me.
Yeah. So first of all, when the whole AI topic evolved and came, the AI Act discussions, but also ChatGPT, large language models, and the whole debate, what was your, let's say, instant reaction and feeling with respect to your day-to-day job as data protection officer here in Hamburg?
Yeah, I think that we acknowledged very early that this will be a very important topic for us. And it's very important as a data protection authority to give guidelines to the government authorities and to the companies, especially in Hamburg. How can they start using this new techniques and these new models? And so we published in 23 guidelines for the usage of large language models, which I think were very helpful because if you can give some guidance for the people working with it in your company, then you have a safe button for the usage of these models. And it's very simple guidance, like don't use personal data for the input and things like this. So what I would like to underline that we try to have a realistic and constructive approach at a very early stage. At the same time, the AI Act developed a lot, and when the AI Act started, there was no discussion about large language models. No. So they had to implement the new idea of AI systems and AI models in this framework of the planned AI Act, and this was a very interesting period, the last months of legislation.
So I assume there was a, let's say, an open debate alongside all the data protection offices in Germany and Europe, and not only you were not only on a personal mission there, I assume. So there was a bigger debate.
There was a bigger debate within all European data protection authorities. Till now, even now, we have on the European Data Protection Board, we are discussing the key questions, how to look at large language models under the GDPR perspective.
Yeah, and I must say thank you very much for these pragmatic advice you gave there. The data protection authorities is like these, what we call AI policies, what all companies now implement. Mm-hmm. Okay, when we now have the GDPR in its, let's say, typical approach, and now we have not only AI Act, we also have the Data Act, we have other new acts where they say use data, whereas we learned as data protection experts, don't use data. How this will work together in future, this potential conflict?
Yeah, I think it's something like a paradigm change that we cannot speak that easily about data minimization as we did those in the last years. There will be a lot of cases where the usage of a huge load of data will be necessary. And if it's necessary to process a great amount of data, then you cannot talk of data minimization anymore. And this will change the look of a lot of different cases, obviously.
Okay, but so that's good to learn and know that the data protection authorities are open to that development and not sitting in a silo, what also sometimes happened.
I mean, everybody knows you need a lot of data to train in a large language model. You will need a lot of data for security reasons. You will need a lot of data for all these European data spaces that are planned. For instance, the European Health Data Space. So if politics and if the society says we want to use a lot of data for scientific reasons, for instance, then we cannot say, look at data minimization, that we have to make possible to use a lot of data on the one hand and to protect the individuals on the other hand. And I think you can combine those views.
Yeah, that's last year when you were here in our legal show, so to say, you said something very interesting. We debated this potential, I don't want to say conflict, but let's say the different interests of those laws and how to resolve this. And you proposed that it would be a good idea if the data protection authorities are also competent for the AI Act, so that you as an authority need to solve the tense between these two laws and not the companies. What happened with respect to that, let's say, debate about who is competent for AI in Germany?
Me personally, I still think that the arguments were right, but I think the political debate went to it in another direction. And from a political point of view, it's more or less decided that the Bundesnetzagentur, which is the former telecommunication authority on a federal level, will be responsible for the market surveillance within the framework of the AI Act. I understand the idea to have a big or huge federal authority for it, but on the other hand, it will be very interesting how we will work together in practice, because there will still be a lot of touch points between the AI regulation and the data protection authorities.
And it's not only like two different authorities, it's the data protection authorities in Germany are on the level of the Länder. So we have for each of the 16 German Bundesländer, we have one. For Bavaria, of course, we have two. And then you have one federal office that certainly also, let's say, adds to the complexity when you need to work together, I assume.
Yeah. I mean, we are used to have this complexity within our system. So I think we could have figured out how to do it within the AI Act framework. And now we will have some approaches to the Bundesnetzagentur to develop, I don't know, common guidelines or a common view on similar cases. So I think we can manage it, but it won't be easier. So I'm not very happy about this political decision, but we will work with this.
And obviously the data protection authorities had been like, they were ready to take over. Is it, I don't know if you can answer this question, is it the same with the Bundesnetzagentur? I mean, it's all very new for them.
I think,
can they operate already?
I think politics really underestimate what it means to build a new authority for such a complex topic from the scratch. And I think it will take years till there is a competent authority that really can deal with all the challenges that occur. And for me, this was the main reason to say it's easier to start with data protection authorities, because we are ready. We know our companies, we know their IT systems. So I think it would have been a much easier way. But as we said,
it's interesting that you predict years to be up and running, whereas the AI Act, at least parts of it, are already kicking in end of February. So theoretically, the authority should be up to speed by end of February 2025. But I also doubt that this will be possible.
I doubt it too.
Yeah, which probably shouldn't lead to the conclusion that one can forget about the AI Act, because sooner or later the authority will be up and running. It's not wise probably to ignore everything.
And maybe it's a realistic approach to say, how can we deal with this situation together? Wouldn't it make sense to have a good cooperation between the companies and the different authorities to create a framework to handle all these problems that will occur? So maybe there's a chance in this period that we can learn from each other and develop a system that will work out in reality.
So from the perspective of our clients, that means if we have an issue where both AI and personal data is involved,
let's discuss.
There's a conflict probably.
Yeah.
They need to deal with two different authorities on this, let's say, similar topic. They have probably two different fines and even two different procedures, which I, from a perspective of someone who's need to deal with that, looks very unpractical.
So as mentioned, I'm sure we will have common guidelines with the Bundesnetzagentur. We will try to look at different cases at the same way. But at the end, you're totally right. There are two different regulation frameworks. There are two different authorities which are look at the same system. So if you have a high risk AI system which processes personal data, you will be under the surveillance of two authorities. This is the mere fact.
And if it happens that this also, let's say, will be processed within IoT, then the Data Act applies, and you maybe have even three authorities, and another one and another one. Yeah.
I think that's the unsolved problems of all these EU digital legislation, that they don't have a combined bureaucratic framework. So, and that every single act, the MIDS AI Act, has its own authority governance. That's a real problem, but we will have to solve them in practice.
How long you think it's going to take until, I mean, we have all this, I would call it, big wave of new EU digital legislation kicking in, I think the start 2022, most of them saw the light. And how long you think it's going to take until this is somehow settled from a administrative standpoint?
Do you think that the data protection system is already settled after 6 years?
Actually, I say no. I think that from the GDPR is now in its youth, so like a 12-year-old.
Yeah.
And there's still time to mature. And I personally think that it all will take 10 to 20 years, actually.
I think it will take 10 years at least, yeah. Probably.
Interesting.
If it's stable in a way. Yeah.
And you are also responsible for the so-called and much discussed Hamburg Theses on large language models, how that work together with personal data. Mm-hmm. Can you share some information? Can you shed some light on your thesis you developed?
Yeah, we thought it was very interesting that more than, let's say, 18 months after the market entry of ChatGPT, a lot of fundamental questions were unsolved and having been discussed. So we tried to come closer to, from my point of view, one of the key questions in this intersection of GDPR and AI Act. How do we look at large language models, and do large language models store personal data in the meaning of the GDPR? And our conclusion was that there is no storage of personal data in a large language model, which means that the storage of a large language model doesn't mean it's a processing under the meaning of the GDPR. And this is very important for the usage of models. This is very important for the rights of the citizens. And it's very interesting that the important distinction that had to be made is between the model and the system. And I think that's something we all learned, that the model is in a way agnostic, looking from the GDPR point of view, but the system is the place, even especially in the output where personal data is processed. And I think this was a very important distinction we made. And it's very interesting now because we have this debate in the EDPB right now, where they create an opinion until the end of the year. And then we'll have more secureness about how to deal with this topic.
I think that's very important. are there, let's say, other opinions on that?
There are as many opinions as possible. No, because I think, but I don't think that this is a bad sign, because it's normal that if you have a new technology and you try to look under a certain legal framework at a new technology, everybody has to try to understand, does a legal framework fit to this technology? And I think it's very clear that the GDPR doesn't fit to models. You can see this at a lot of points. And yeah, but there are different opinions which say then you have to make it fit. And this debate is on now. And as I said, at the end of the year, we will know more.
What do you think will happen with our good old GDPR in the light of all these new EU digital acts, where they ask for, let's say, data use, like Data Act, AI Act in particular, those acts, and that's the opinion of the legislator, they say you have to exploit economically data. Our GDPR says you shouldn't use data. We talked about that very briefly at the beginning. Do you think that is something like the end of the principle of data minimization?
I think the sentence that the GDPR is untouched by all the different digital acts, the sentence can't be true. Of course, the way I look at the GDPR, I look at a law, has to reflect other acts which interfere. Maybe it's always the fact, if you are a law maker, that you know that different laws interfere with each other and have to be seen in a coherent way. So I think it will change the way we look at some aspects. Let's say if we have if you look at legitimate interest, the need for the usage of large data amounts, you will have to reflect if you prove if there is a legitimate interest. And so in a lot of details, the view on the GDPR will change because of other acts of the European Commission.
I think that's an extremely interesting observation, because you were referring to that sentence, the GDPR remains untouched. We probably need to clarify this sentence. You can find in mostly all of the new acts. So it's written in the act, or at least in the foreword, that as a matter of principle, we have a new law. However, the GDPR remains untouched. And I was always a little bit surprised. I mean, should we have these silos, or there need to be an interaction? And now you confirm, well, the sentence is probably not totally correct. There will be like some kind of interaction between the laws.
Absolutely, yeah. I think this is a realistic approach, because the interpretation of law will change if we interfere with other laws. I think that's like that's reality.
And the practical question is, of course, how can we solve the tension, if it's a tension between, or the different interests between those laws? And you already referred to the justification and legitimate interests, so that you probably, and it's good that we have this instrument because it's flexible, that we need to interpret that principle in the light of those new laws.
Exactly.
And if I would have a wish list, what I would like in those new acts is not the sentence, the GDPR remains untouched. I would like to have a justification.
Sure.
Something like article whatsoever says, let's say, GDPR justification, and then the law itself tells us, if you do it in that way, it's justified also under the GDPR. Do you see a chance that, as you said, the sentence saying GDPR remains untouched will be changed in future? I talk about the next 10, 20 years, so that you see if we have new laws, that they may put a bit more flesh on the bone, helping the users or the companies to find justification?
I don't like to think too much about coming legislation because you never.
We have enough.
We have enough, and you don't know how long it takes. You don't know which EU Commission will be able to create a new digital act. So I don't think that much about this, but I'm very sure that we will solve a lot of problems by interpretation. There will be a change of interpretation of the GDPR because of the other acts, and this will be the touch point. So it will be touched by practice, not by other laws.
But I have a practical example which we previously discussed together in the NIS2 directive, where we have, and thank you for saying interpretation, we have already adjusted, let's say, a hint, not a proper justification, but at least in the recitals, it's 121 of the NIS2 directive, it says if you implement, this is IT security, cybersecurity in such a way, that could be a justification under Article 6, Para 1, C or F GDPR. When I was stumbling over that justification, I said, oh, wow, this is what I would like to see more. That's very user-friendly. You think that was an accident or from the legislator, or you think we will see more of this guidance in future?
Yeah, I think we will see more of this guidance because in this special case, it makes sense to have this point of view to this special topic. And it's interesting that we have first examples even the other way around. We have, if you look at this pay or okay case from Meta, then we have an influence of the DMA to the GDPR concerning third options in context of digital advertisement. And so we have will have a lot of practical cases where we interpret the GDPR in a different way because the DMA has some articles which regulate kind of the same topic, and so it makes sense to have an influence from one act to the other.
Yeah, that's going to be very important because sometimes, from a perspective of the authority, let's take cybersecurity. The one authority or the one law says you need to let's say, implement measures. Cybersecurity is very important. However, if you do so by, for example, checking email boxes, you certainly also touch personal data. And then the other authority says, don't touch personal data. And I know all these data loss prevention tools, they are subject to so-called blacklists. So you need to do data protection impact assessment. So from a perspective of GDPR, data protection authorities, these data loss prevention tools are, let's say, dangerous. So you need to check it very carefully. Now we have the new law and they say, well, you need to do this, so it's justified. Maybe we don't need a, let's say, such a strict view in future in those areas.
It's a good example.
Interesting. Well, the international dimension. We talk about European law, but we all know it has an international dimension. Do you think the AI Act also will have a similar so-called Brussels effect like the GDPR?
I think this is not decided yet. I think it's really an open process. On the one hand, we see companies not starting with new products in Europe because of the AI Act or because of a kind of unsecureness about the legal basis of some of their products, Meta, for instance. On the other hand, we see legislative ideas in a lot of countries, especially in California, now has created a new AI Act. So I think it's still not really clear which direction it will go. But obviously, everybody's looking at Europe and is studying very carefully the AI Act and the impacts it has on companies and on the markets.
Yeah, in particular, as all the EU laws, they have already, let's say, international reach, so the territorial applicability is quite immense. So everybody who's doing business with Europe need to follow the rules, also if they are outside of the EU. Yeah. Interesting. But do you see, let's say, looking again into the future, now we have a new area, probably with Trump back in power, and everybody talks about deregulation. We want to, let's say, we don't want to have rules. Will this have an effect for your practice? Do you think so or not?
I like to make a difference between deregulation and less bureaucracy. I think this is very important to divide these two subjects, because I don't see an era of deregulation, because every modern society wants to embed new technologies in common interest. And so we will still have a regulation for all these new phenomena. But what we have to do is to do this regulation in a less bureaucratic way. Maybe the practice of the GDPR is a little too bureaucratic, and maybe a lot of other laws could be lived in a easier way, let's say. And so I don't see deregulation, but I see efforts to have less bureaucracy even in this digital context.
But that sounds that's a good answer, and that sounds like good news actually, because that would be very helpful for those who are dealing with all these laws. You must imagine, like our clients, and in particular from, let's say, mid-sized companies, they have already a lot to do, and then they have all these topics. One person sometimes or two, they have all these topics on top of what they do already. Very big companies, probably not so much a problem. They're very big, large legal teams. But for the smaller one, it's very hard. And now, let's say, final question: what is your recommendations for those mid-sized companies, in-house lawyers, in-house data protection officers, who suddenly see that on their table there's a big pile of new regulation, and they all need to digest and give advice to how can they do this without getting mad?
I think the first advice is don't be afraid. The second advice would be if you know what you're doing with your data, you're on a good way. So have a clear conscience about which data you store for which reason. I mean, the basic work you have to do if you're a data protection officer. And I really think now is a period of cooperation between companies and authorities. And so I would advise every company that do so in Hamburg, come to us, let's discuss how you implement, for instance, AI models in your IT systems, how we look at this, how can we combine the protection of personal data and the innovation power that AI has. So I think the main advice is get in touch with your data authority and let's discuss how we solve the problem that are on the table right now.
Thank you very much. I think these are a very good, famous final words. Know what you're doing and start the dialogue with your authorities, in particular in this early period of all these new laws. Thank you very much, Mr. Fuchs, for stepping by and sharing all your very interesting thoughts with us. Thank you very much for listening. See you next time. Have a good time. Bye-bye.
Thanks for having me. Bye.